Good evening, ladies and gentlemen. What happened in Perak in last year was not a constitutional crisis. It was a crisis of many kinds, but not a constitutional crisis. I'll explain in a short while. Saudara-saudari sekalian, dalam pandangan saya, apa yang telah berlaku pada tahun 2009 bukanlah satu krisis perlembagaan. Ia menunjukkan bahawa ada beberapa krisis yang berlaku di Perak dan di negara kita. Tetapi dalam pandangan saya, krisis itu bukan satu krisis perlembagaan. Saya akan cuba sekejap lagi saya akan menerangkan mengapa saya berkata demikian. 各位朋友，晚上好。2009年霹雳所发生的事件，在我看来，不是，我重复，不是一个宪法危机，它是种种的危机，但不是宪法危机。待会我会解释为什么。Let me first deal very quickly with the legal aspect. Now, articles have been written on this, books can be written on this. Many reasons can be given. Just now, Datuk Sri Niza gave a few reasons. I will just approach it with two angles and give two very brief reasons, because the thing is so clear to me. Now, in law, what must we have? We need fairness and justice from two angles. One is the substantive angle, the other one is the procedural angle. I will now explain why I think in both these approaches, what happened last year, justice was denied, justice failed. First, the substantive angle. Now, I just want to quote a very short passage from an article written in 1982, long before, more than 20 over years before this, called The Role of Constitutional Rulers. In there is this sentence. It says this, I quote, "Under normal circumstances, it is taken for granted that the Yang di-Pertuan Agong would not withhold his consent to a request for dissolution of Parliament. His role under such a situation is purely formal." Now, this applies, of course, also to the states, although the writer was writing about the federal government. Okay, what does this mean? Under normal circumstances, it is taken for granted. That is, it's something so obvious, right, that the Yang di-Pertuan would not withhold his consent to a request for dissolution. Now, in law, what does withhold mean? Withhold is different from refuse. Withhold is wider than refuse, right? Because a person can say, well, you need my consent, I'll think about it for a week, or think about it for a month. That's not refusing. I'm not refused you yet, I'm withholding my consent. So, the Yang di-Pertuan Agong, according to this order, cannot do that. Cannot even withhold. Cannot say, let me sleep on it, let me wake up tomorrow and see how I feel. Alright? Now, that's the second point. Thirdly, his role under such a situation is purely formal. Not just formal, purely formal. Which means that it is a formality, he actually has no choice. Now, it is so clear in law that what happened in Perak, and of course, if you remember, the sentence starts with under normal circumstances. No abnormal circumstances has ever been shown, whether in the public arena or in court, that what happened on the 4th or 3rd or 4th of February 2009 was special, was abnormal. Alright? So what happened is clearly in conflict with this passage. So I, as a lawyer, I'm puzzled. Maybe because I'm not a good lawyer, so I don't understand this. Now let me tell you who is the author of this paragraph. He was the Lord President at that time, 1982, and he is the current Sultan. So I think must be my own inadequacies that my legal training and my practice for so many years, I cannot reconcile the two. I'm sorry. Procedural fairness. We are having Thomas Cup, isn't it? So Thomas Cup, let's say. Malaysia lawan China, okay? Over lah, tapi tak apa lah. Malaysia lawan China. Malaysia, every time protest, line call, not accurate, cannot overrule. China, every time protest, line call, not accurate, overrule. Okay? Now, if this person is injured, if he wants to have an injury time, say 2 minutes. Malaysia 2 minutes. China 10 minutes. Fair or not? Look at what happened in 2009. The High Court ruled in favor of Nizam. The very next day, a stay is granted. Very efficient. Then after that, within 11 days, the judgment was overturned. Very fast, very efficient also. Good. Now then what happened? Then they went up to the federal court. Was stay granted? No. Was the case heard within 11 days, 22 days, or 33 days, 44 days? No. I counted. The decision was given 167 days after that. So, how does it look? Procedurally, how does it look? Right? Remember, it must not just be fair, it must be seen to be fair. Now, you can go on for the next 3 days to list all the reasons, but there's no time and no need to do that. From the substantive point of view and the procedural point of view, I, as a trained lawyer, cannot understand what happened. I just cannot understand. Maybe my IQ is low, but I cannot understand. Alright? Okay.